Okay, well, it's 1:30, after 1:30 now, so we'll get started. Welcome, everybody. My name is Eric Hauge, and I'm the Executive Director of Homeline, and you are joining us on Wednesday, January 27th at 1:30 for another one of Homeline's COVID-19 Tenant Landlord Law webinars. And today we are joined again by Managing Attorney and Tenant Hotline Director Mike Vraw, as well as our exciting guest speaker, Attorney Kim Tennyson of Tennyson Law. And I'll let Mike introduce her in a little bit once we go through a couple opening slides. Just a reminder what Homeline is for new folks that are joining us today. We are a statewide nonprofit organization that provides free and confidential legal advice and information for renters throughout the state. And we've been open since the early 90s and have advised over 260,000 renters. We average about 1,000 households a month that we advise. And our services are available in English, Spanish, Somali, and Hmong languages. We have been, there's our hotline number. Any renter that has a question about their their rental situation, legal question, can contact our hotline in the metro area or toll free from Greater Minnesota. And we do have language specific lines, but there's also language prompts on our main number. And just a reminder that today is really meant as a general information session, really specific to COVID-19 pandemic related tenant landlord issues, but we'll field some other questions too, I'm sure. If you're a renter and you have a very direct question about your situation, please give us a call and or go to our website and ask your question that way so we can give you direct individualized information. And just a reminder, we've been doing these sessions since last April when we were doing them a little bit more regularly, but we are going to continue these for the time being. The next one will be in 2 weeks on February 10th. Another 90-minute webinar on Wednesday the 10th, and we're going to have a couple guest speakers on that session as well. A couple legal aid attorneys, Catherine Pauck from Legal Services of Northwest Minnesota and John Buda from Southern Minnesota Regional Legal Services. So they advise renters and represent renters in rural areas in Minnesota. So they're going to talk a little bit about their perspective. I'll throw the registration link in the chat at some point, but you can also just go to our website and register for that one. I'll mention again briefly two more things. I think it's our intention, we did not apply upfront for CLE credit for today, but it's likely that we will apply after the fact for CLE credit for attorneys for this session and likely for the one on February 10th. If we get those approved, we'd follow up with folks via email with the codes. And then as always, we got a lot of questions in advance for this session, so we're going to jump into those after Mike goes through sort of a brief update. But if you do have questions, there is a Q&A chat, a Q&A submission system in Zoom, and we prefer you submit them over that system if you can. And with that, I'm going to hand it over to Homeline's Managing Attorney and Hotline Director, Mike Vraw.
Thanks, Eric. I am hoping that today is not like the last session that we did, which happened to be on January 6th. And I think I was one of maybe 4 or 5 people in the United States that didn't know that the Capitol was being breached as I was in the middle of giving one of these 90-minute presentations, and I sort of shut down all my other devices when that's going on. So I was the only person not aware that everything was happening. So I hope there's nothing like that today. All right, let's focus on the Minnesota moratorium on evictions, the CDC moratorium on evictions. What we've been talking about since last April is the hurdles that landlords have to get past or over in order to be able to file an eviction. And this is the easiest way to sort of conceptualize this issue, is starting with the Minnesota hurdle. It's the biggest hurdle. It's the most important one that a landlord would have to get by in order to be able to file an eviction for non-payment of rent. In Minnesota, non-payment of rent evictions, typically in a normal year, well over 90% of the evictions that are filed in residential where people live evictions is for non-payment of rent. And so not being able to file for non-payment of rent is a huge shift in landlord-tenant law in landlord-tenant relations in Minnesota, and at present, a landlord simply can't file an eviction for non-payment of rent. So when will that end? When will the eviction moratorium or moratoria be removed? Well, let's start with the Minnesota eviction moratorium. The current status is that it lasts until February 12th of 2021, so a few weeks from now. The reality is, though, that it might get renewed. It's been renewed 10 times already. So this eviction moratorium is tied in time to our peacetime emergency that all of us in Minnesota are very familiar with. The peacetime emergency is what grants Governor Walz the power to close a restaurant down, or a bar, or a salon, or a church, or a gym, or open them up to half attendance. All those things that we've seen on social media, in the newspaper, and we've heard about, are sourced with this peacetime emergency authority that the governor has. Tied, as I mentioned, in time to that peacetime emergency authority is the state eviction moratorium. Now, this peacetime emergency can be granted for 30 days at a time by the governor. And after the 30 days, the governor has to say, I want to do another peacetime emergency extension, 30 more days. And I think, as near as we can tell, the governor can do that infinitely. However, at some point, the legislature is likely, I mean, if the governor tried to do this forever, eventually the legislature is going to step in and say, no, you can't do that. But what's required from the legislature to stop the governor from continuing to renew these 30-day peacetime emergency declarations is that both chambers of the Minnesota legislature, so the Minnesota Senate, controlled by Republicans, the Minnesota House, controlled by Democrats, would have to tell the Democratic governor, nope, you can't do another 30 days. Now, there have been several votes, 5-6 votes on these already. And when there was no legislative session occurring, every time a 30-day renewal occurred, there was an automatic special session started. And in those situations, I think all but one of the times, there was a vote by both chambers. Every time there was a vote, the Senate voted to end the peacetime emergency. Every time there was a vote, the Minnesota House voted not to end the peacetime emergency. So those are the two starting ways that the peacetime emergency would end. Either the governor stops doing it, just doesn't do another 30-day extension, or the legislature decides to end the governor's power, including the eviction moratoriums. The last way is that there could be a court challenge. Some landlord group might take the governor to court and say, hey, judge, we think that this is unfair. The governor shouldn't have this kind of power, and we want you to rule this unconstitutional, whether it's at the state or federal level. There are exceptions. There are still evictions being filed. There aren't many being filed, but there are evictions being filed. A landlord can file an eviction for the tenant seriously endangering others on the premises, causing significant property damage. If the tenant has violated a statute that predates COVID by a long time, the no drugs, no guns, illegal drugs, illegal guns, sawed-off shotguns, automatic weapons, you've been convicted of a felony. There's actually a list of the drugs and of the guns that are not allowed. Prostitution or contraband in the property, that's an exception. And the last exception that really matters is the family exception. So the owner wants to move in to the property, and the lease, it's not in the middle of the lease. So if the lease goes through the end of August, a landlord can't say, well, I want to move in, so I want you out by the end of February. It doesn't work that way. But if it's month to month, they might be able to use the family member exception. The landlord, the owner, or their family could move in. That's really the exceptions that we have, which is why evictions have been reduced to a trickle of what their normal numbers are. Let's go on. I should mention also that this isn't just evictions, the moratorium. It's also non-renewals. A lease non-renewal, or a notice to vacate, a notice to quit. There's a lot of phrases people use to describe it. What I'm talking about is the landlord giving the tenant a notice saying, you know what, our lease is over. I don't want to do another one with you, whether it's month to month or 1 year. Those aren't allowed either right now under the governor's executive order. Go ahead and roll the slide, please, Eric. Okay. Next issue, I mentioned a court case, a court challenge could occur where some landlord or group of landlords would say and ask the court to end the peacetime moratorium, or at least the eviction portion of it. And that was tried. Late last year, we actually got a decision on New Year's Eve, where federal judge, this was filed in federal district court instead of state court, which didn't make a ton of sense to me, but that's where they filed it. They made all kinds of arguments, constitutional arguments. Having read a few of these from around the country on different types of orders that governors or the president has given, the arguments that landlords make are pretty similar. So are the ones that the governor makes or the president would make as well. The argument that the landlords make is this is unconstitutional. Sort of at the core of their arguments is this is not enough due process. There's not really a legislative thought going into this. This is a violation of the contracts clause. This is an unfair taking, something like eminent domain. Those types of arguments are the ones that landlords put forward. The government counters with, more or less, it's a pandemic. We're trying to stop the spread of a deadly virus. And one of the ways we can do that is make sure people stay in their homes. And so we're going to exercise extraordinary authority. Anyhow, this case was heard federal district court. And like I said, the decision was issued the last day of last year, and it ruled against the landlords. So in the first federal court at the district court level, the court agreed with the state that the governor is allowed to continue to do this. They cited a couple different things. The taking question. So where landlords were saying, hey, you're taking our property by not allowing us to file an eviction. The judge really leaned on a couple of issues. One is that the rent is still due. So the landlord isn't really necessarily losing their property. They just don't have the same type of legal action to pursue to enforce it, the normal one, which is the eviction case that a landlord might want to file. The exceptions that I talked about earlier, the significant damage to property, the seriously endangering others, things like that, seemed also to matter to the judge in the decision. Additionally, the judge pointed out that eviction is not forever barred, it's just barred temporarily. And the last one was that the landlord could still sue for money. An eviction is a very strange kind of legal proceeding, and it's incredibly limited. The judge's job in an eviction hearing, usually, ultimately, is to say who gets possession. That's really what they do. The way I always describe it to people when I'm trying to really boil it down is if everybody walked to the front of the courtroom during an eviction case and set all the keys to the rental unit in front of the judge gets to decide who gets the keys at the end of the case. And that's really what a judge does in an eviction hearing. A landlord winning an eviction technically means that they win the place. Now, a lot of landlords think if they get paid, most evictions are for non-payment of rent. So if they get paid all the money that they're due, then they're winning effectively. But that's not truly winning an eviction case. All right, go on to the next slide, please. So I mentioned that the state hurdle is hurdle number one. Now we come to a smaller hurdle. This is a federal hurdle. And I've done landlord-tenant law since 1997, and I've given a lot of speeches, over 1,000 speeches. And one of the things that I will frequently say is that state law is kind of everything when it comes to landlord-tenant law, and that's becoming less and less true. It's certainly not that true necessarily right now for a couple of reasons. Number one, we have the CARES Act order. So the CARES Act, for those of us that remember, was passed back in, I think, March of last year at the federal level. So we had, once again, we had a Republican-controlled Senate, a Democrat-controlled House, President Trump, also a Republican. Passed very, I don't think it was unanimous, but it was awfully close to it. It's the one that authorized unemployment, additional unemployment benefits and the earlier stimulus payments to people, along with a lot of other things, but it also had some language about evictions. And it banned evictions in CARES Act covered buildings. Now, this statute, the CARES Act, sunsetted, that's the word lawyers like to use. It ended in late July, on July 25th, at least the part that was banning evictions from landlords for non-payment of rent. It wasn't all landlords. It wasn't all rental situations in the United States. It was only ones covered by the CARES Act. And the CARES Act said who's covered. It's anybody that's got a federal type of subsidy involved with the housing. And it actually used a really broad definition, anyone covered by the Violence Against Women Act. It's a broad umbrella. Or even a smaller building that might have 4 units that has a mortgage that's federally backed by Fannie Mae or Freddie Mac, for instance. Those would also fall under the CARES Act. Now, the only reason we still talk about it, because it's sunsetted, is there's a 30-day notice requirement built into the CARES Act. So for a CARES Act covered property, and our best guess is 20 to 50%, it's not really a known number who gets their mortgage where. Anyhow, 20 to 50% are probably covered by the CARES Act in Minnesota. So if all the moratoriums went away tomorrow, the state one and the federal one from the CDC that I'll talk about in a second, the CARES Act 30-day requirement would still be there for a landlord that was covered by the CARES Act. That did not sunset. All right, let's go on to the CDC order, hurdle number 2 at the federal level. And this is the one that, honestly, this causes confusion for folks. I know we have a question that was already submitted in advance, which seemed to think that this was the only one that mattered in Minnesota. And we get those questions from tenants on our tenant hotline, where we get well over 1,000 calls a month. But here's the actual story, the logistics right now. So the CDC, Center for Disease Control, passed, based on an executive order from President Trump at the time, back in September, a rule forbidding all evictions in the United States for non-payment of rent through the end of the calendar year, so through the end of 2020, okay? That was effectively renewed through a legislative agreement. So it was, I think there was actually a bill passed, signed by the president, extending, there was a lot of other things included in that, extending the CDC protection through January 31. Since President Biden took office, he has extended that through the CDC, the same method that President Trump used last September, through the end of March. Okay, so we have the state moratorium on non-payment evictions through February 12th at least. We have the federal eviction moratorium on non-payment of rent cases through the end of March at least. I believe President Biden has asked Congress to extend that through September, but that's not official yet. Nothing's been signed, or certainly the legislature has not taken that up seriously as of yet. A couple of key details about this. This only protects tenants facing eviction, once again, for non-payment of rent. The CDC order, the CARES Act, the state moratorium on evictions, every single one of these orders or legislative acts has said that the rent is still due. It's clear. There's no real vagueness about this. Everybody understands that the rent is still due. That doesn't mean all tenants are paying all the rent that they owe. We know that's not true. But the rent is still due. When this all began back in March, our office was getting questions on a daily basis from tenants wondering how to form a rent union or go on rent strike or how to get their rent canceled. All these kinds of questions. We don't really get those questions right now. Maybe we will when the moratoriums go away. I'm not sure. It's going to depend a lot on how much money is available at the federal level, mostly to help subsidize rent that's been unpaid. But the rent is still due. Every one of these executive orders and legislative acts states clearly that the rent is due. One question that we get frequently is, are late fees allowed? The only one of the three, again, we have the state moratorium, the CARES Act, and the CDC order. The only one of the three that really addressed late fees explicitly was the CARES Act. And it stopped late fees on non-payment cases in CARES Act covered buildings through the end of July of last year. So that sunsetted. So from August till now, there's no law that I'm aware of that certainly covers Minnesota that stops late fees from being assessed. A landlord can still ask for late fees. The CDC order explicitly defers to the state moratorium. The state moratorium is the specific deference that it has because there's more protection there from the state. There's a couple complicated arguments that in some cases the CDC order might be more protective, especially for the family member exception, but I don't think that's been litigated in Minnesota as of yet. But those are the hurdles that we need to be aware of. Why a landlord can't yet file an eviction for non-payment of rent. And we're asked all the time, when are these moratoriums going to go away? When will a landlord be able to file an eviction for non-payment of rent? Landlords want to know it because they want to be able to plan their financial future and figure out what their options are. Tenants want to know it because if they've been out of work because they lost their job because of COVID and they're not able to pay their rent, they want to be able to forecast their future as well and see when the deadlines are going to hit. Right now, I think it's somewhat safe to say that it looks like April 1st would be the first day a landlord would be able to file an eviction at the earliest. That seems to be a conservative guesstimate. But these have been extended before, and I think it's going to have a lot to do with how the vaccine rollout is going, how the numbers are, how many hospitalizations, how many cases are being reported, how many fatalities in not just in Minnesota, but maybe nationwide as far as how long this will go. I mean, if we all get vaccinated and everybody wears a mask for a month and we social distance, maybe all of this stuff won't need to be done anymore. We can all hope for that, I guess. But so far, that sort of result that we all are fantasizing about hasn't occurred. So I think April 1 at the earliest, and I would not bet much that it's going to be April 1 as far as when landlords are going to be able to file evictions for non-payments of rent. But that's just our best guess right now. Okay, go on to the next slide. So yeah, put up all the bullet points too. Today, we are lucky to be rejoined by a second-time guest. Kim has been on, I think it was last, do you remember, Kim, when you were on our session last? Was it summer or was it fall?
I think it was mid-October.
Mid-October, there you go. So yeah, Kim Tennyson is an attorney that works with landlords. She represents landlords and evictions, and she also does a lot of trainings for landlords and staff. I'm a tenant attorney. That's all I've ever done. I've never represented a landlord. Kim has represented a lot of landlords in a lot of different jurisdictions throughout the state on not just evictions, but other issues as well. And so we like to have Kim come in because she knows her stuff. And it's nice to hear the perspective of somebody who's on the other side of the legal fence, if you want to put it that way. And so what we're going to do with Kim, she does not have a prepared speech. She does not. So she is going to be answering a bunch of questions that have been pre-submitted and ones that we're getting right now. Now, some of the questions that we get aren't really for her. They're about some other issues, and we'll help answer where we think we need to. But most of these questions are going to be for Kim, and she's going to be answering them. So, Kim, are you ready for this?
I think I am. I mean, I'm used to answering questions on the fly. When people call, I don't have any idea what they're calling about. And as you know, I many years ago did volunteer at Hotline on the hotline. So
yes.
It's sort of like doing that, but sometimes it's a little confusing trying to keep track of who's asking a tenant question and who's asking a landlord question. And
that always does help when people submit if they say landlord or tenant just in parentheses at the beginning of the question, so you get the perspective, because you can usually piece it together, but not always. But you know what? We've got a little over an hour. I can't imagine us getting through all the questions we've got, but let's give it a shot. Yeah, because I know that we have a lot. So I'm going to start off with the first one, which is from somebody named Liddell, a landlord. Their question is, can we give intent to evict notices now?
The answer is, in a word, no. That, as Mike covered, is under the category of giving notice, terminating a lease, or non-renewals of lease. And those are also prohibited by the Minnesota version of the moratorium. And to give notice of an intent to evict now would be really premature, since we don't even know when we can evict. And there may be some pre-filing notice that is required at that time. Like right now, even with the exceptions, there's a 7-day pre-filing notice to the tenant, letting them know in advance that there will be an eviction filed. That's for those that qualify under the exceptions. That's different. That's new. That's something we didn't have before. I don't know if that will continue, but we've got that in place now. But to give any sort of an intent to evict, I think would be a threat of eviction. It could equate to something that is a violation of the moratorium. And there could be a penalty for that. They could report that to the Minnesota Attorney General's office.
Yeah, Kim, we've actually seen notices to terminate the lease effective for some time this summer already, where the landlord is terminating the lease that far out in advance. So is that not allowed? Is that your sense of it too? Something so far well past the moratorium's stated deadline at this point?
That's my general advice. That's been my feeling about it. I did run into some people who, when this first happened in March, continued to give notices because they just had no idea that this would still be in place by the time June came around or July came around. And I think it came back to sort of catch them on the other side that, well, you gave this notice, but now you're kind of stuck because the tenant might just stop paying the rent, but they're not going to leave either. And you can't file for holding over after notice. So
yeah, so got a contemporary question asked about what we're talking about right now. A landlord is trying to figure out the right language here. They're saying to tenants right now, because of your account balance, you are on our pending eviction list for when COVID moratorium orders are lifted. What do you think of that?
I haven't seen that one. I haven't heard that. I think it's a little threatening. I suppose somebody maybe could get away with just a general note saying, by the way, we know there's a moratorium and we can't evict anybody, but that doesn't make the rent go away. At some point it will be due. But to say you're on our list, I think is a threat of eviction, which could, by some parties, be interpreted as a violation of the moratorium.
Well, and I can tell you, if we had that in our office, a tenant that called us up with that, we would send it on to the Attorney General's office, because honestly, it doesn't matter what you think about this or I think about it. It's what they think about it, and ultimately a court, but they're the ones that enforce this. And so I would absolutely send that on to them saying, this isn't as direct as I'm going to file an eviction right now, but it's still, like you said, a threat of an eviction.
Yeah, I advise not making anything that even sounds like a threat.
Okay.
And I think that kind of a notice that we intend to evict, that is exactly what it is. It's that kind of a threat that the Minnesota Attorney General's office wouldn't like.
Fair enough. The next question, I think, is really about monetary assistance. And I don't mind you answering this, Kim, but I'm going to have Eric answer the first sort of portion of it. A lot of people wrote in, landlords, tenants, social workers, saying, what are the rental assistance options? When should tenants apply? Where do they apply? What financial support in the future? Are there going to be new funds available? Can tenants make up months, if not almost a year of rent somehow through financial subsidies? So Eric, what's the latest on the financial help on the way?
Yeah, so and there's one other question that was asked that I moved up. Somebody asking about Anoka County back last year because Ramsey and Hennepin County was handing out rental assistance directly for landlords. And so that's kind of in the same bucket. And so I'm going to answer all these sort of at once. Well, I think what's important to know right now is that there's been multiple buckets of funds that have been opened beginning, last spring through the summer into the fall and the winter. A good portion of that was state funds in July, August of last year. It was actually federal dollars that then the governor decided to put towards Minnesota Housing Finance Agency, and then they set up a COVID housing assistance program. That program ended. The last day you could apply for that was in December 7th of last year. Other jurisdictions, like one of the people asked about, like Hennepin and Ramsey, they did set up their own programs. There were differing programs in other counties. Some cities set up their own programs. A lot of those funds are now done because they were tied to federal dollars that only could last for a certain amount of time, but now have been extended. So there's kind of a confusing mix of programs that were out there. Some of them were only for tenants to apply. Some of them allowed landlords to apply. So the important thing to know right now is that a lot of those are done, and we're kind of in a bit of a interim period. There was a program that Congress passed, and it was signed into law on December 27th that put a lot of money towards rental assistance nationwide, but there's an estimated $375 million that's going to come to Minnesota. It is going to the state. It's split up between the state and jurisdiction, and certain jurisdictions that have a large enough population. Those jurisdictions are Anoka County, Dakota County, Hennepin County, Ramsey County, and Washington County, as well as the cities of Minneapolis and St. Paul. So the state gets 55% of this. Those other jurisdictions, and I believe some tribal entities, get the other portion. And it still is in the midst of getting set up. So that they just, I think, had to agree to accept the dollars recently. Just yesterday, there was a hearing at the Minnesota State Legislature, and I'm going to actually put in the chat a link to the presentation that Minnesota Housing did, because it has all this information that I'm sharing with you. And it has information about who's going to be eligible for that, how they're going to be eligible. The problem is right now is that it's not a program yet. They're still setting it up. There's, $375 million that just flew into the state for rental assistance. It's not easy to just turn that into a program and get it out the door. So that still is in the works. And I think what I've heard is, and there's been questions about, is there going to be an option for landlords to apply? I think the answer to that is that they're considering it. Again, I think, this is split up between the state and some of these local jurisdictions. So hopefully there'll be some coordination between those. But, there was sort of a one-stop shop when Minnesota Housing had the funds last year. You called 211 or you went to United Way's website or Rent Help MN. I can't remember what it was. Hopefully they're going to do that again, and there'll be a one-stop place where tenants can go, and potentially landlords. Maybe I'll stop talking on this front right now and just, I guess, reiterate, this is not set up yet. Tenants, landlords can't apply yet, but there is a substantial pot of money that is going to be available for rental assistance.
And that's real money. That's not hoped for money. The federal government's already authorized it, correct?
That's correct. Yep. And
the 375 million. Yeah.
Yep. And so I'm going to put in the chat again. There was testimony by the Commissioner Jennifer Ho of Minnesota Housing yesterday at the state legislature. Page 8 of this PDF that I'm going to put in the chat is where there's information about this program, and I'll put a couple links. But again, I think it's just the caveat is that this is not set up yet, but they're working on it. My understanding is that they have to actually spend these funds by the end of September of this year. At least that's what the current law is. Otherwise, it can be reallocated. So there is going to be some strong interest in them getting this out the door in a efficient, consistent, fast manner. And the dollars can go to past due rent, and my understanding can also go towards future payments in rent if tenants expect that they're not going to be able to come up with rent in the future. Some of those details are in the thing that I'm going to put in the chat.
So Kim, let's jump to you on this.
Yeah.
What are you advising your clients? I mean, are they asking you about the money part, or is that something you just don't get to?
I usually mention it myself because most of the people, random calls, random landlords that I might hear from don't seem to be aware that there's money. And more recently, of course, I've had to tell them a lot of that is gone. You kind of missed that opportunity, and so did your tenants. From the very beginning, I've advised you really need to work with these tenants, maybe help identify where you can find some funds. That was way back in April, May, June. And I have some clients that were able to help with that. I've heard from landlords too that are, I guess, skeptical and think that if their tenant finds funds, it's just going to be paid to the tenant and it will be gone. And I have to assure them that it doesn't work that way. These are earmarked funds. They're going for rent. That's the purpose. And then more recently, I think in trying to explain to people how tied our hands really are, nobody ever really intended that we'd still be here 10 months later and with unpaid rent. And I believe it was always the plan, at least for the state of Minnesota, to help with some of this funding and take with relief, basically. It's just too little too late and not enough people knew about it. But I certainly address that. I tell people, call your city, call the city where the property is, call the county, call United Way, see if you can tease out any information that will help you get landlord funds or might help your tenant with funds. And
sure. And I don't see an issue with a landlord saying to a tenant, hey, I'm not sure if you know about this program. You're the one that needs to apply, but here's the contact for it. Yeah. You're welcome to look into it, or you should look into it. All right, let's get back to some of those logistics about the eviction moratorium, things like that. So we got a question, kind of combining questions again, because we got a lot of similar ones from Guy, Angela, and Sarah. And I think they're asking about whether evictions are any different if somebody's really behind on rent. So will evictions, will there be any additional recourse for badly delinquent tenants that haven't been paying rent for almost a year? It's causing the landlord a financial hardship. Can that landlord evict? Is there some sort of critical number of months behind where a landlord could evict for non-payment of rent right now?
There's not right now. It's all unpaid rent. All unpaid rent is just categorized the same, whether it's 3 months behind or a year behind, and some of them probably are. As far as, I think this will evictions be on schedule relates to when things open back up. And I sort of read it as, will there be some kind of priority for
Oh, sure.
more extreme cases of delinquency, but I don't see that really happening either. At least it's not been mentioned. And typically the court would accept filings or take in filings in the order they come in, and they would schedule them in pretty much the same way. So unless they come up, when this is done, unless they come to some other decision and rule, I don't see that really changing. I don't know how they would triage all of those cases and know that they're validly prioritized.
Yeah, because some people only pay $500 a month in rent and others pay $4,000. So somebody that owes $4,000 in the $500 a month a place would be behind 8 months. Be hard for the court to see that with a quick glance at the eviction complaint.
They don't validate anything
Right.
that comes in. That acceptance by the court, by the way, I think that word is always kind of misleading because it tends to sound like they have validated something. And I think landlords sometimes think, oh, okay, I've got this eviction. And really all it means is that you paid the fee and they read it and it had party names and it looked like an eviction. So it doesn't mean it won't be dismissed for some sort of other grounds. I just wanted to throw that in there because when we're talking about filing and acceptance, I think that can be where your head goes, is that it somehow validates it. And they don't validate these. They don't read them that carefully.
Okay. So another question from Tamara and Courtney, combining them again. So this question to me has some misinformation, but I don't mind trying to address that. When February 1st comes and landlords can evict, how overwhelmed do you see the system getting? And when will the current eviction moratorium be lifted in Minnesota? So I know what they're thinking about February 1st. I get it. They were thinking the CDC order was set to expire on January 31. But that's not the order that truly matters in Minnesota. It's certainly not the first in line order. But that's why they're asking it. Honestly, it's why we've done these sessions since April, is so we can try to share the most current information. But yeah, can you go ahead and answer that?
So February 1st, as you said, that is not going to be any date for any sort of activity in evictions. At the very least, Minnesota could let it go February 12th, but it still wouldn't matter for non-payment of rent because we've got the federal moratorium that will continue. How overwhelmed do you see the system getting? That's a really good question. I think that's what the courts and the court staff and attorneys, all of us have been talking about for months. They do have a plan in place. And as of the last time I heard an update on it, and probably the last time you did, it was maybe October, as far as how they were going to handle them. And I'm sure they're continually thinking about this, but they will handle the backlog first, and then all of those cases that didn't meet an exception, that got filed and held on to, but didn't meet an exception to be heard. And then they'll start taking the other cases, and probably in the order that we talked about, because how else are you going to sort them? I do see it being very overwhelmed. I think we've talked about numbers for months. It's unknown, but with 95% of evictions being non-payment of rent, this is going to be really difficult. I don't see it moving quickly. We already know that some of the statutes of limitations and rules related to timing have been lifted temporarily. So what might have been a 2 weeks to receive a summons, and that's 2 weeks not from filing really, it's 2 weeks from when the court decides to let that summons out and have the schedule. I don't think that's going to be 2 weeks. I don't know how long it's going to be. I've seen in other cases or other circumstances, for example, Ramsey County did a merger of courts a couple of years ago. They had a lot of stuff going on internally with civil and housing. And I think I waited a month for a summons, and that wasn't even that big a deal. So I don't know how backed up things are going to be. I think it's going to push everybody into really saying, okay, now's the time. Where are we going to find the funds? Tenant, what are you going to do to avoid an eviction on your record? And that's about it. I mean, it's all unknown, but they're working on that having that system, but there's only so many hours in a day, you know?
Sure, fair enough. All right. Karen asks, we have a non-paying tenant, so this is a landlord, who allowed their 7-year-old to play with a lighter. Fire caused minor damage in the fourplex. So what do you think? Would that fit the significant property damage exception to the state moratorium?
I think it could. I mean, I would need to know more myself. I'd have some questions about it. I think it could potentially also fit danger to others. So there might be two in there. The problem with those two exceptions is that they do fall under breach of lease. And in order to have a breach of lease, you need to have a lease. So one of my first questions would be, is there a written lease? And then is there something in that lease that is it more than a piece of paper? Is there something that addresses safety and responsibility? And also, does it contain a re-entry clause? That's the clause that really reserves the right for a landlord to even file an eviction for a breach of lease. So assuming I could ask a few questions and get to some kind of a conclusion here that, yes, I think a child who is living in a building, plays with a lighter, starts a fire, causes damage, I think that could possibly qualify for both of those exceptions. But it's really fact specific.
Yeah, I think they all are. The questions like this are very fact-based. In fact, just looking at the question, she said that the 7-year-old caused minor damage, which you could argue, well, that's not significant. It doesn't sound like.
And I was stuck on that part too. I would say, no, it's either damage from fire or it's not. I don't really see fire damage as usually being minor. So I was a little stuck on that word when I first read it.
Right. Okay. Another question from Michael and Liz. Can landlords sell their property currently? Can a landlord evict if they're selling their property?
Landlords can sell their property. A landlord could not evict because they're selling their property. That's not an exception. A tenant, a lease, first of all, a lease or a tenant always goes with the property. So while it's pretty typical for a landlord to try to maybe give notice to vacate and get somebody out of the property before putting it on the market, that doesn't work right now. So technically, yes, they can sell, and the tenant and their tenancy and the lease, if there is one, will go along with the sale. But that means that the buyer needs to be ready to assume that. And in a lot of cases, what is the obstacle here is the financing. That financing is going to usually require, if somebody wants to live in the property, they need to be move into it, be able to move into it. And the borrower needs to be able to say, yes, I'm going to live there. I'm going to live there now. And if not, if it's identified as an investment property, then they need to be getting different kind of financing. And that's usually what I run into in conversations with real estate agents who invest, or my clients that invest, or whomever calls. I used to be a broker, so I deal with a lot of transactions. But you can sell. There's nothing to stop you from selling other than the current circumstances, but you can't evict in order to do it. And you can't notice either.
So a new question from Mike. If a rental's been abandoned by a tenant, how can the owner recover possession?
I think we've had this one before, and I guess the answer is it depends. Abandonment is always kind of a weird thing. There's not a real clear definition or any parameters to tell us when something is abandoned. The easiest case would be somebody saying, I'm leaving, here's the keys, and then so again, really fact specific. I think I would probably have several questions in order to try to drill down to figure out if this really was abandoned or if there's some other problem. I heard from somebody who had what seemed to be an abandonment issue, yet the person didn't take their dog and kept returning to feed their dog. And that was, I don't know whatever happened with it, but that was tricky too. Like, what is this person doing? Did they go and move, but they couldn't have a dog, so they decided they'd just leave the dog behind? So I think it was a weird circumstance, and they all are. The keys is the best example. Leaving things behind or versus taking everything with them, that might indicate something, but there's not a hard and fast rule of time elapsed to say it's abandoned. And then you still need to care for the property, the personal property, either on premises or in storage. Premises on-site is 28 days and off-site would be 60 days. And there's other rules for that. And that might be part of this question as well.
Right. And look, Eric mentioned earlier that if a tenant has a question today and they have a lot of detail and specific detail, they should contact our free tenant hotline. The same is true for a landlord. If they have a question like this, you're available. I mean, I'm not sure exactly what you'll charge, but you'll tell them what you'll charge. I assume that's what lawyers do, to try to get to the answer. But it's not a simple, oh, here's where you can look it up and there's the answer to your question. Like you say, you need a lot of facts to be able to give them the right advice versus general advice.
Right, right. And I wouldn't want anybody to walk away thinking I've told them no, when maybe there's some potential there.
Sure, sure.
Or vice versa. So
Okay.
yeah, everything is really fact specific. And sometimes it's the fact they think doesn't matter. So.
Sure, sure. Okay, from Levi, again, a landlord. What maintenance obligations do we have for renters that are severely past due and beyond their lease? So he's tying the rent being paid to maintenance obligations of the landlord.
Yeah, and you can't connect them that way. The landlord still has that covenant of maintenance and needs to make repairs. There's no holding repairs back for the rent, even though they are not paying the rent. And that's always the case. When the day comes to be able to evict for non-payment of rent, I suppose that tenant might have a defense for maintenance. My questions would probably be related to what kind of maintenance obligations are we talking about? If there are code violations, that could raise the level of severity into something related to habitability. And a tenant could file a rent escrow action now. Those are not on hold. So yeah, you have to do maintenance.
Okay. So it's not like we haven't really addressed this question, but I'm sure you've gotten this sentiment already. And this is a question from Ellen, but from other clients of yours. And here it is. When are the owners going to be free from this mess? That person is renting. They get free rent. They don't have to pay. And she's saying, good luck trying to collect that money later. So you must talk to clients, landlords that are just kind of exasperated by all this. And what are you telling them?
Yeah, I tell them, look, none of us knew that this was going to happen. This was not planned. And I usually tell them the story about how on March 16th of 2020, I got a call from the court saying, you have a hearing tomorrow, call the tenant and tell them we won't be here and not to come to court. You don't come either, and we'll get back to you in a couple of weeks. They never did. None of us ever heard back on anything. And here we are 10 months later. And that usually sort of frames things up like, wow, you don't know either. And we don't. We have absolutely no idea. We can watch the news, listen to the governor, and we can guess at certain things sometimes by piecing things together. But we have absolutely no idea when this might end. I was more confident that it wouldn't end when we were coming up on fall, winter, because this is Minnesota. And I really didn't see this ending in November, December, January. But I think with spring coming on, we can cross our fingers that everything is better, but we have no way of knowing. As far as the comment about good luck getting the rent money, I think that really goes to what Eric just talked about with there being some funds out there. There might be some luck in getting some funds for either the landlord or the tenant. So I would definitely pursue that and talk with the tenant, see what their plans are, see if they actually want to leave and they feel trapped. Maybe they'd go.
Well, I know that feeling that you just mentioned about people thinking that we have some sort of inside knowledge and when the moratorium is going to be lifted because we're lawyers. And I think people give our office a little more undeserved credit for knowing what's going to happen because we've given these speeches for so long. But we don't have any insight into when this is all going to end other than what we're reading, like you said, in the newspaper or online, and trying to glean from all of that what our best guess might be. It is frustrating. A lot of this is frustrating. So anyhow, new question from Wendy. Please discuss the issue of a holdover house guest who contributes toward expenses but doesn't pay rent. Are they residential tenants?
I'll start with the second part of the question. Are they residential tenants? Probably, because they live there and they have been contributing something. So nobody's going to say they're not a tenant. It doesn't take a lease to be a tenant. It doesn't take a written lease to be a tenant. It sounds like there was some sort of an oral agreement anyway that contributed toward expenses. And then this gets a little more complicated. I don't know what these expenses are, how regular it was when they were paid, if it could be counted as rent. And I'm thinking, maybe I'm thinking wrongly, that this person knows that the holdover house guest is kind of a problem. That's that accidental landlord situation sometimes that actually invokes a different notice requirement when you can give notice. And that would be 3 months notice, because there is no rental obligation. So I would want to talk about whether they're really an at-will tenant versus an at-will tenant without a rental obligation, deserving of a 90 or a 3 month, right? Everybody says 90 day. I think the statute says 3 month notice. So basically what it says is your notice period is either the time between the rental obligation or 3 months, whichever is less. And if you don't have a rental obligation, then it's 3 months. And that's where we get into that depth there. So yes, I think they're a tenant, and it's questionable whether they deserve a 3 month notice or something less. They probably don't have a written lease that helps us decide that, but those notices cannot be given right now either.
Okay, I've noticed, Kim, that since we began, we actually have more questions now than when we started.
No.
So I'm going to try to I'm going to bunch more together and make them as brief as I can. What do I do if Section 8 isn't paying their portion? This is from Alexis. Section 8 isn't paying their portion of rent because the landlord isn't making repairs.
Yeah, that one kind of confused me, because I did read this earlier, but so it sounds like a landlord question, but then it says landlord isn't making repairs. So I thought maybe it was a tenant.
It might be the tenant, or maybe a social worker or something like that. Yeah.
Yeah, maybe it's a neutral party. Those are always kind of sticky. Usually it's the landlord and the tenant blaming each other. The landlord says it's the tenant's fault that we can't get in, or it's the tenant's fault that these things are broken again. Section 8 is really the middle person. They don't really represent the landlord or the tenant. And so it's hard to work with that. I would definitely need to know more, but I think the tenant could probably file a rent escrow action, because those are still available.
Sure. And if the landlord wants to get paid by Section 8, then they could make the repairs, and then Section 8 would probably pay.
Yeah.
Be the other solution to that. Yeah.
Kind of a circular question
Right,
there.
right.
I'm not sure which side it's from.
Understood. Okay. This is from a landlord. Janelle asks, when will the eviction moratorium be altered so that non-contracted squatters can be removed? Possible drug use and sale.
Okay, I'm going to go to the second part of that again, because drug use and sale, as you addressed earlier, still could fall under the covenant, the mutual covenant, really, of landlord and tenants, not to have any against unlawful activity. So that's Minnesota statute 504B.171. That's a grounds for eviction that's available and has been. It never went away. It's not a breach of lease claim. So if, depending on the level, that might be available. When will it be altered? When will the moratorium be altered? We don't know that either.
I would not hold my breath for alterations of the moratorium, that's for sure. We got indications from the governor back in August when there was the most recent change. We're on our third version of the eviction moratorium right now in Minnesota. And the governor indicated that there wouldn't be any more tweaks at that point. So I'm not sure that I would count on a change there.
I've thought about it over and over, and I can't even figure out where you could put a tweak right now. You know?
Sure. Okay, Dan has a question. I'm pretty sure this is a landlord, and this is a question that we get, honestly, almost every time we give a presentation. How can the government have power to control my private property?
Well, we talked about the case that was already heard, and that was similar. It was a possible takings case. I think that was their claim. Essentially, just the mini law school lesson in constitutional law is that when there is something affecting the health, welfare, and safety of the community, state, city, county, there can be regulations enacted to help with those things. And I think that puts it on a different spectrum of discretion and having more latitude. They have the latitude to do this to protect us. At least that's the premise, and that's where we're at with it. So it's not really, they're not controlling the private property, but I know it doesn't feel that way.
They're regulating it, certainly. And without the eviction availability for landlords, they're regulating it a lot more, for sure. But yeah, landlord-tenant law honestly wouldn't exist if we weren't going to regulate it. There wouldn't be a reason. You just say there's a contract, both sides have to follow the contract. Landlord can put whatever they want in, the tenant can argue, but but there's not a state in this country that doesn't have regulation of rental property to some degree. So it's already sort of been decided, Dan, long before COVID, that the government has some role in regulating landlord-tenant relations. Okay, Michael asks, my tenants, so this is the landlord, my tenants are not wearing masks in common areas.
Yeah, I would have some questions. I think we've talked about this before. You can warn the tenant, you can warn them again, you can make masks available. I guess at some level you might consider whether they're a danger to others, but you'd probably need more information for that. Are they walking around trying to infect people? I mean, what is the deal with the masks? What's happening? Where are they wearing them? What kind of common area? It's certainly a violation, but as we know, they're not really doing anything about that. It's not being enforced. So outside of meeting an exception, there's not an eviction grounds for that.
What advice, from Samantha, what advice do you have for landlords that want to remodel their property before selling their homes and ask the tenants to leave?
Yeah, I'm not sure from this if the tenants have already been asked to leave and they're not, because that would be a violation of the moratorium because their lease can't be terminated. They can't be given notice to vacate. I think this goes to the other question about, can I sell my property? Yes, you can sell it, but you're not going to be able to evict for that purpose. So, and I'm not really sure how you would work with remodeling depending on the extent of it. If you're talking about a whole home makeover, you really can't do that while there's a tenant in there. And they wouldn't have to cooperate with that, I don't think. I think that would be beyond reasonable. So yes, you can sell. I would probably want to know about this ask tenants to leave, because it's not always an automatic. If we look at commercial properties, commercial spaces, retail centers, those leases go along with the sale. And it's the same for residential. That tenancy goes with it.
Okay. From Emma, what sort of evidence are judges currently accepting as proof that a tenant is a threat to others on the property?
So I've done a couple of these where I've had some damage or danger to others.
Where have those been, Kim? Which counties were they in?
Hennepin and Ramsey.
Okay.
First of all, an eviction action is what's called a summary proceeding. And the first hearing is really not intended to be an evidentiary hearing. So you have very limited opportunity to even let them know what happened and start doing this sort of back and forth, he said, she said kind of a thing. That said, you do need to have some sufficient framing of the problem in your complaint in order to pass muster to get to that next step of getting a hearing. Because if they're actually reviewing these individually, the referees, at least in Hennepin and Ramsey, are looking at them. I waited a week for one of mine to be reviewed. They're looking at them and deciding and signing off on them as something that can get a summons issued and get into a hearing. And what I would do is just make sure that if I've got a valid claim and that all of that paperwork is also filed into court, because at least that way they can see it. And if one of the clinics is looking at it, they can see that information too. So I've got the lease there. I've got any complaints, any police reports, things like that, just ready in there, because otherwise there's not an opportunity without going to trial. Breach claims in general require a trial unless they're settled at that first level of the first hearing. So even in the best of circumstances, eviction for breach of lease is not great. It's not a great position to be in. And of course you need that written lease as well. So as far as evidence, you just need to know it's accurate. This is not a workaround. It's not a loophole. It's something happened. Here's the information. Here's an explanation of what happened, and somebody was injured or something was damaged.
So Katie asked a very similar question. Significant property damage. I mean, what would a judge say is good enough for an eviction there?
I don't think any of us really know exactly, because we're not really hearing, and most of these are settling or they're defaults. I think I'd have to hear it, and if I heard it or saw it, then I might know. I had a story where a tenant took what did they take to the door? Oh, a hammer to someone's door, another tenant's door. That was a case of a combination of things, of damage to property and danger to others. And it was worse than that, but that could be damage. I mean, you have to have damage. I think a question has come up before of, well, I think they're going to damage it because they're really upset and they don't take care of the property. Thinking there's going to be damage isn't enough.
It has to be past tense.
It has to be damaged. Yes.
Okay.
Yeah.
From Nan, we think it's a social worker. Our clients appear to be only 1 month behind on rent, if at all. What are you seeing in Hennepin County? Are landlords actually suffering?
Oh, that's a really big question. I don't know. I only represent some landlords that have properties in Hennepin County. Yes, they're upset. I'm sure they're suffering in many ways. Not everybody is only a month behind on rent. So maybe there's not a lot of sympathy for this landlord. I'm not quite sure where the question is coming from. Hennepin and Ramsey are probably really similarly situated as far as that.
Do you see a difference in metro rent being current versus non-metro?
No,
Okay.
I think I have a wide range of probably just enough of a sampling that it looks equal to me. So
But you're hearing from clients that they have tenants that are well behind in rent.
Yes, many, many.
Sure.
They've been very patient. I think the patience is going to be, if it hasn't run out already, I think the next 60 days or so are really going to be hard. When we hit that 1 year point, I think it'll be different.
Sure. Okay. Fred asks, I have a tenant who will not allow us in to do maintenance on a sink and to do follow-up work on some pest control. So I think he's wondering what can he do about that?
Yeah, I hear this one a lot too. And one of the things that I even say in trainings is one of the few things that a landlord can do is actually give notice to enter for a reasonable business purpose. And it probably is one. They don't need to consent, but you do need to notify. And if somebody is not allowing you in, a sink, it could be a big deal. Is it leaking? Is it causing other damage? I think you got to be clear though, because if you don't give notice, that's a violation as well. It's a violation of the right to privacy, but on the flip side of that statute, there's also the management's right to enter. So it's one of those few things a landlord really has to work with is the tenant doesn't have to consent, but you do have to give notice and explain why you're going in. What I usually
What's the landlord's remedy though now if the tenant doesn't consent? I mean, I guess Fred might argue that he could file an eviction if the leaking faucet will cause damage or is causing damage, right?
If it is, I think you could. But if it is leaking through to a unit below and that ceiling is all ruined now, that might be sufficient. That might even be significant damage.
Okay.
Yeah, not enough information though.
Sure. Timothy asks, I know a private landlord who rents out one home who currently has a tenant he'd like to get rid of now or at the end of the lease. Tenant's not paying rent, but has managed to receive some COVID funding. The tenant is up to date as of December. The tenant is also not paying the water bill, which is being added to the landlord's property tax because of a local ordinance. What can the landlord do, if anything? And does he have to renew the lease in May if he does not want to? He's worried the eviction moratorium would be extended so he can't have the tenant removed and the tenant would become a holdover, preventing him from selling the property.
That's a lot of questions all in one thing.
There is.
We already dealt with the selling. As far as water bill, I usually advise, and nobody ever listens, but I usually advise that the water bill be wrapped into the rent and not be assigned to the tenant, because I think almost every city in Minnesota, hold on.
The Capitol isn't getting stormed again, is it?
No, it's not.
Okay.
And I can't make it go away. That is really strange. Okay, I think I might have got it. I actually have it on Do Not Disturb. Sorry about that.
Sure. It all happens to us.
Right, well, we'll just have to get through it. Just 1 second.
I will answer part of Timothy's question, which is, I don't think the landlord has to extend the lease for another year. I don't think he has to renew it. Once it rolls, or once it ends, the tenant, if they continue to stay there, probably is going to become a month-to-month tenant. So if the moratorium is lifted at some point in the summer, then the landlord might be able to give a notice, 1 month's notice or 2 months notice at that point
I don't think there's ever any obligation to extend a lease. So yeah, that's not a problem. But I would usually, as far as the water bill, yes, at some point it's probably going to get wrapped into the eviction, but it could be a problem if the landlord doesn't pay the water bill. And
Sure.
that becomes another circular problem, because now did you cut off their utilities because you didn't pay it? I think there's a question there.
So a slight deviation from COVID. John, one of the Minneapolis City Inspections Department folks, asks, what's your perspective on the Minneapolis Renter Protection Codes, the new ones that have been passed, the tenant screening and the security deposit ordinances, which are now in effect for all Minneapolis landlords. They were sort of phased in if you were a larger landlord with a certain number of units. It was effective last summer. Then on December 1, it was effective for all Minneapolis landlords. What are your thoughts on the new ordinance?
Well, as far as experience with dealing with questions on it, it really hasn't happened because it's so new. It's 7 weeks old, as far as most of my clients. And we haven't really been able to use it as far as giving notices and having security deposits and dealing with all of the details of it. It is the question about perspective on whether it is valid or invalid.
Yeah, it's hard to be exactly sure what they're asking there. I think they're just looking for your opinion of those ordinances.
I was surprised at some of the details of it. I thought it could be an overstep. I think at some point it may face opposition legally, but it's so new. I haven't heard from any of my clients or any other client, potential clients, asking about it.
Yeah, and what I would tell any smaller landlord that isn't in this and this is their only line of work is chances are you're using a screening company of some type, and at the very least they must be aware of what these ordinances are and they're going to help you comply with them. And so I would be, if you're a little bit confused about that, that's a company that you're hiring. They should know how to do screening that's complying with the laws if they're using one of those companies.
You would hope.
Yes, you would hope. Otherwise, they shouldn't be a tenant screening agency. Absolutely. All right, next up from Megan. How are domestic violence programs navigating the no evictions if clients refuse to leave safe housing? So I guess she's saying you got I think a victim that won't leave is what she's saying. Is that your sense of that question is too? So I know you have it written in front of you too, Kim.
Yeah, I do. If clients refuse to leave safe housing, I'm not sure if this is a landlord question. Oh my gosh. I don't know why it's doing that. Here, hold on a second. I'm gonna mute this. Hold on.
While you're working on that, I'm gonna just mention, I think I saw somebody submit a question. Now I feel like I lost it, but somebody asked a question about getting a link to the new CDC order. So I'm gonna put that in the chat. I actually haven't seen a new CDC order. I think it's the same CDC order. But there was a press release from the CDC saying they're extending it. So I'll put a link to both of those in the chat.
It is tied just to an executive order, I believe, Eric. Again, there's no legislation on it, so it might not be very lengthy. It might just be we're extending exactly what was before. So there might not be a lot to find. So Kim, back to that domestic violence thing. Yeah, I'm not exactly sure.
I'm not sure of the point of the question, or if it was a tenant question or a landlord question. If clients refuse to leave safe housing, I'm not quite sure. I don't work with the domestic violence programs. I will advise a landlord on how it works and letting somebody out of their lease. So.
Okay. So from Deanna, how will this go once the eviction hold is over? What will be the long-term effect on tenant records?
Who is planning ahead? How? We talked about that a little bit. I mean, I know that they're talking about it. The courts are talking about it. They're trying to have processes in place. As far as putting as evictions being on someone's record, yeah, that's a big concern. I think maybe if there continues to be, I say, a 7-day pre-filing notice, at least tenants would have the chance to leave before a filing takes effect, because once it's filed, it is on their record. I don't know that the courts would have the authority to actually demand any sort of a sealing of the record or an expungement. It's going to be up to the parties to decide if they're willing to do that.
Okay.
there's going to be a lot of people with one on their record. So
Sure. This question for Eric, if you don't mind putting up a link or two. Somebody's saying, I'm looking for subsidized housing. I live in Anoka County, St. Francis specifically. If you could throw up a couple links of places that they could try to consult.
Yeah, and I'll put them in the chat. I mean, the main one we refer to is Housing Link, but there's some other resources for finding subsidized housing.
From Julie, back to you, Kim. How to deal with a no pet policy with service animals?
yeah, I don't know if that's quite enough information. And then the question is, are we talking about service animals or are we talking about companion animals in a building that already has a no pet policy? We'd have to look at whether a reasonable accommodation needs to be made for a service animal and related to a disability. I mean, I don't think that you could, for example, turn down a seeing eye dog if somebody really needed it and it was possible to have it. So I think we'd need more information, how to deal with, it's not real specific.
Eric, this is another one where I think you're just going to be posting a link. Somebody's asking, is there any data on eviction cases that have been heard during COVID-19? We actually did a webinar a little after the last one with Kim. So this was in late October, where a couple of folks from our office, Andrea Palumbo and Leah DeGrazia, presented a session on some statistics about evictions filed since COVID-19 had begun. It's the only one I'm aware of. Maybe somebody else has done one that's more modern. That was October 28th. But again, it's been a trickle of cases since the moratorium began. Normally there's 13 to 17,000 residential evictions in Minnesota each year. And I don't know what the numbers are this year, but it's not going to be, or in 2020, but it's nowhere near that, obviously.
Yeah, I'll put the link to the recording from October 28th. But yeah, we've been monitoring since then on a weekly basis. And, things have stayed fairly consistent. We see, things slowed down a little bit around the holidays, but in a regular week, statewide, we're seeing anywhere from 15 to sometimes 30 or 40 a week.
Okay. From Kimberly, a tenant is supposed to fill the propane tanks and refusing to fill them. With the cold weather, we, the landlords, concerned about damage from frozen pipes. Can we force her to fill the tank? Could we file an eviction under the damage exception as imminent, or do we have to wait until the actual damage is done?
I think we kind of talked about that. It would have to be that the damage is done. Anticipating damage wouldn't be enough, I don't think, under that exception. And then I question the, how did it end up being the tenant's responsibility? And it is their utility, but you might have to just pay for a tank of propane and make it a debt. Save the property.
Yep. Kimberly actually asked a series of questions. There's 3 total. So different tenants not paying their water bill. The city of Bloomington will not shut off the water and will assess to our property taxes. Can they do that?
Yeah, I think almost every city, if not all cities in Minnesota, do that. This is why I was, before that phone call weird thing, it didn't come through my phone. I usually say, make sure that you're getting the water bill covered in your rent, or somehow estimate something where you know that you're going to be able to pay it, because this is what happens if the tenant doesn't pay it. And I have seen some cities just refusing to shut it off.
Okay. And our last pre-submitted question, we have a policy that the oldest outstanding balance or oldest outstanding debt is applied to the balance. So you make a payment that the oldest debt is what's paid first. Are we allowed to apply that payment to the outstanding balance before the new month rent of February, which would then leave February short, and then late fees would kick in? So essentially, let's say somebody didn't pay January's rent and there's a late fee that's kicked in. So then the tenant pays all of February, at least, but they still owe January. Would the new February late fee accrue? I think is what they're asking, I think.
I think that's what they're asking too. I guess for accounting purposes, I probably wouldn't do it that way. If I'm filing an eviction, I file the late fees separately, and I will usually break it down. I get a ledger, and I will usually pull out the rent as full rent and the payment as full payment, and then add the late fees in, because it's not always clear whether late fees are even going to be covered. And under this circumstance, I would go back and make sure that there wasn't a late fee that might have applied during CARES that is applicable to CARES. And then I wonder, it's 8%. You can't do late fees on top of late fees either. There's no compounding of late fees. So I would really want to look at the accounting for that. But I would separate it. I know yes, you can. It's statutorily as well. You can apply rent to the oldest balance first. And I do it that way. But I would probably pull out the late fees for eviction purposes.
Okay, I'm going to skip a couple of questions because they've sort of been addressed, but we're on to ones that have been submitted since we began. From Jean, will the people receiving federal subsidy be eligible for the rental assistance? And I'm not sure if this is Eric or Kim that wants to take a stab at this one. Will the people receiving federal subsidy be eligible for the rental assistance?
I'm not sure I understand the question.
I think this is maybe getting to the chat program, which the requirements for that did not allow people that had subsidized housing to apply because based on income, because in theory, if they didn't have income, then their rent would drop to 0 or close to. I'm not sure the answer to that. Some of the materials I put in the chat about the new program might discuss it. I was just going to make one note, and maybe we can reiterate this at the end. Last year we had a lot of different sessions like this with the different guest speakers, and actually one of them, right after the state started their program, was staff from Minnesota Housing. So it's our intention that we try to have some experts come in and talk about that when that program does get up and running. I don't know the answer to it right now, and all the details for that new program are not ironed out yet.
From James, my tenant has refused to pay rent for no reason other than to avoid paying it. He refuses to cooperate by applying for any funds, and it's impossible for me to get funds without him requesting it. So there's not really a question there, just kind of a frustration statement. But one of the things I will point out here is that the CDC order requires the tenant to give a declaration that they've been trying to get whatever money that they could get, but that's not a rule in Minnesota. So I don't know if that's exactly what he's asking or if there is a question built into that, but any thoughts, Kim?
I think you're right. I think this person knows something and saw some suggestion. I do get calls sometimes. They say, but they don't have COVID. They didn't have COVID. They have no reason to not pay the rent. And I have to explain that the Minnesota moratorium is not about that.
Sure. From Jake, if landlords receive forbearance from their lender and part or all of that forbearance is shifted to the end of the loan, essentially making it a loan modification, is there a legal argument that can be made by a tenant that the forbearance should apply to the rent that is owed? Like, since somehow the landlord doesn't have to pay their mortgage, that the tenant doesn't have to pay their rent as well. I think that's what Jake's asking.
I think it is, and they are mutually exclusive. So the rent obligation doesn't go away even if somebody's not paying the mortgage. Even if a property's in foreclosure, it gets a little muckier than that. But they're completely separate things. So I don't think there's a great argument there.
Okay. From Jake, I'm curious to know if there's any advice for owner-occupied single-family rentals in terms of eviction or issue resolution. If you rent a room or basement and the tenant isn't being safe in terms of preventing COVID transmission. Is that seriously endangering others on the property? Do you think that could rise to that level?
Maybe it could, with some more facts and some more information. Maybe it could. If somebody's really that worried, I suppose they could try to test it. Being that these are new exceptions, it's really hard to know what's shaking out in these cases, or if they're even being decided consistently. So it's worth a try, maybe, but it would depend on the facts there too.
Sure. From Rebecca, will the metro counties consider an all hands on deck approach with judges and referees for housing court matters when the moratorium is lifted? So they're going to fully staff and be able to handle all the cases when they need to.
Yeah, I think Hennepin and Ramsey are probably going to be the busiest. Maybe Dakota, Anoka, a couple of others, and you named some that are working with funding. They must know that they have a need. I would think they would stick to their own districts and not blend districts, and they are divided into judicial districts. There are some counties that are combined into the same one. So maybe Carver and Dakota would team up. I think otherwise, I don't really, it's not been addressed in anything that I've heard.
Well, I will say this, that the entire court system is backlogged. It's not just landlord-tenant issues. And so hoping that judges could drop everything and help out with all the eviction cases, I think you'd probably need judges that can devote time to it exclusively. So maybe a retired judge, which we've heard some of that being bandied about in some judicial districts, that a retired judge might come in and work on eviction cases here and there. A lot of this is going to depend on the volume. And a lot of the volume is going to depend on how much money actually gets to tenants and ultimately landlords to pay rent. So it's a kind of unknowable thing right now, but it's a fair question to ask, is how is the court system going to handle this, or how are they going to try at least?
It sounds efficient, but
Yep.
I don't know if that's something that's feasible based on the way everything is structured. They're all going to have their own problems.
From Carrie, a tenant claimed the Proud Boys targeted her and kicked in her door in November, so she left the property. She left food out, trash, mice came in, and she refuses to come back and remove property due to safety concerns. There was no police report filed by the tenant. Can this qualify under the damage to property and UD exception? UD, of course, being unlawful detainer or eviction. I don't think we've used that phrase today.
Right. Perhaps. I thought it was going to be a question about abandonment.
Mhm.
So I think I would probably look to the tenant to see if they would confirm that they have abandoned the property and they're not returning. And in that case, maybe you wouldn't need an eviction.
Yeah, if you can get confirmation from the tenant saying that they've left, go ahead, place is yours, I don't want to be there anymore, at least you don't have to file the eviction. If you get something in writing saying that, an affirmative statement of abandonment is much better for the landlord as far as risk management goes. So I would try to reach out to the tenant if they are contactable. Janelle wants to piggyback off Levi's earlier question, which is, does the landlord have a duty to repair if the tenant's not paying? What if there is no contract with the squatter in the home? Are we still obligated? I think she's...
Yeah, the word
Yeah.
squatter kind of throws me off, but assuming that they have some sort of occupancy and possession that meets the definition of tenant, like they live there, they get mail there, even without a written lease, there is an implied statute in Minnesota that says that maintenance must be done.
Okay. Catherine asks, is there a comprehensive list, county by county, that's been created about funding available to tenants for the rent? This would be great for both sides. Eric, do you know of anything like that?
There is a Minnesota Housing has a page that has a lot of different links and info on materials. I think part of the problem here is that things are kind of constantly changing. So I'll put in the chat the link there. And of course, again, the new program is still in the midst of getting set up, so the details aren't there yet.
Can we, Kim, for you again, can we non-renew a lease now for a resident who's smoking in their apartment in a non-smoking building and it's bothering the neighbors?
No, I don't think so.
What if the next door neighbor's got asthma or something like that? Would you argue the seriously endangering others?
Maybe it could be danger to others. Maybe you could classify it that way. I hesitate to make that some sort of a loophole catch-all kind of a thing because it really is specific, but I suppose it could fit that, but you can't terminate a lease at all. And that would go to the Attorney General's office and be a violation.
From Guy, the person at my property has no written lease and is being destructive to the property. Does this qualify as an emergency eviction situation? They are, in my opinion, vagrants. I don't think we've had that word in any one of our sessions, but here we go.
Yeah, I'm not sure what that exactly, how those people were defined. I think it probably could be. You don't need to have a written lease. Well, you do have to have a written lease to use the exceptions. Yeah. Boy, that's tricky. There's no written lease at all. And what are they doing to damage the property? I guess is the question then.
Right. You'd want to talk to Guy directly to try to pin this down to see what options he's got. That's fair.
Maybe there's something else.
Sure.
You can always ask them to leave or pay them to go away. We didn't talk about that today.
So this is a different question from Terry. Can a property that stopped taking Section 8 before the moratorium but allowed tenants to finish their leases follow through with this now that the peacetime emergency is in place?
Follow through with.
So I think they're trying to the landlord had announced apparently that they were going to stop taking Section 8, but they let somebody, keep their current lease that they were in, but the moratorium came in, but now they want to still not take Section 8. I'm not sure I understand the financial wisdom of that from a landlord's perspective, because Section 8 is probably paying a decent percentage of the tenant's rent.
Yeah, and from a tenant perspective, they can't be evicted. So I'm not sure why, if this is a landlord question, why the landlord stopped taking Section 8 only to end up leaving them there. I kind of talked about this before with the whole giving notice to vacate, and then they're not going to pay rent. If they pay rent, you waive the notice to vacate. And now you're stuck with somebody and you can't file for holding over after notice either. So it's kind of that, you can't have it both ways.
Okay. From Wendy, here's a new question. Does the CDC order apply to all properties or only the properties covered by the CARES Act?
It applies to properties covered by the CARES Act, but I think the problem has been identifying those properties, because if you ask anybody if they have, for example, Fannie Mae or Freddie Mac backed mortgages, they will say, oh, no, I don't. I got it from a bank. And that's not the answer. They have to dig a little bit to find out if the CARES Act applies. Right,
but I think really what they're asking is, does the CDC order only work to cover CARES Act covered properties? And it's more expansive. The CDC order is all properties, all rental properties in the United States, versus the CARES Act, which was really limited. So the current federal prohibition is much broader than the old one is.
Because the current prohibition for non-payment of rent, the moratorium for non-payment, is not CARES.
It's the CDC one, right? Yeah. From Todd, any ideas on what will happen when the moratoria expire and all of the rent becomes due? The seemingly will be a disaster, as there's likely little possibility that past due rent can be paid and landlords will not be able to pay their obligations.
Yeah, I think that's what a lot of these questions have been talking about and suggesting. I have no idea where this is going. I don't know if disaster, I hope it's not a disaster, but that's why we're looking at a lot of this funding and really trying to get the word out that there is funding, because this can't really be easily handled or efficiently handled, even when the day comes that people can file evictions. It's going to be crazy.
And Kim, I should have asked you this earlier. Are you able to stick around for a few more minutes?
Sure.
At the end of this, let's go till 3:15. We've got that much for questions. Anybody that wishes to sign off, of course, you're welcome to. It's not like we're taking attendance or anything. But if you want to hear answers to more questions, we'll get to as many as we can up till 3:15. Is that all right with you as well, Eric?
It is. And can I jump in on one thing really quick?
Yeah, go ahead.
There was something that was submitted in the chat from a landlord talking about that they're waiting on a tenant who had applied for some of the CARES funds or maybe the CHAP program, and waiting for one of the administrators of that program in St. Paul. And the tenant's behind and they're still waiting on it. So we don't have the answer to all that, but I guess one thing that I sort of jumped over is that the program that the state had, the chat program, where applications ended December 7th, I think some of those are still in motion. And so this website right here, Minnesota Housing's website, is that's kind of the FAQ on if you submitted your application to that program. Again, if it was before the December 7th deadline. Some of those are still coming through. There's delays in it, and so it might be true in this particular question that the tenant is still waiting.
Okay. All right, Kim. So what can be done with tenants that don't keep their unit clean? We have a tenant that has so much trash in their unit that you literally cannot walk into it without stepping on trash. Is there a resource for us or for the tenant?
Are we talking about a potential hoarding situation?
Yeah, I think that's what they're describing. Yeah.
There might be some sort of social services or agency that might get involved. And then on the flip side of that, if the city gets involved, they might just say, you can't live here. And now everybody has a problem. I'm not aware of a resource like that, but I don't run into that too often. I've seen it after the fact, after somebody vacates and it's floor to ceiling stuff.
Fair enough. From Catherine, what actions has the AG's office taken regarding allegations of a landlord violating the moratorium? What have you heard, Kim?
I have heard that they've been taking it very seriously. It seems that they have a lot of staff devoted to it, that they are addressing these violations, and I don't think they're leaving anything out. They are actually pursuing them, and it is it's a misdemeanor, criminal and civil misdemeanor, I think. And if anybody is trying to file ahead of time, we haven't talked about this for a while, anybody tries to file an eviction ahead of time, it could be possibly accepted by the court. It won't be scheduled for a hearing, but it could be accepted and sitting there. And those would also be subject to a penalty.
Sure.
So don't do anything in advance. But yeah, they're on it.
From Amy, who's a landlord, if you can prove that a tenant has not lost their job and is just refusing to pay rent as they were way behind before COVID, can you evict them? They've broken the lease in five different ways, but just can't get them on proof of damages or other major violations.
Then I would say probably not.
Yeah, sort of built into that question is do you have to show that there was a job loss or somehow that you are deserving of the protection of the eviction moratorium? It's kind of built into that question, but that's just not in the state rule, right?
It's not a qualifier. Yeah.
Right. From Emma, if a landlord attempts to file an eviction on a tenant right now, will that show up on a tenant's record, even if the case is ultimately thrown out? And in a similar vein, if a landlord files against the tenant and the tenant loses, will that case still show up on the tenant's record?
Yeah, it does. I mean, they're there as soon as they're filed. Now, whether some courts are hiding them temporarily, I don't know. But typically, as soon as it's filed and accepted by the court, the fee is paid, it shows up, even if it doesn't get scheduled for a hearing. So it's probably would be sitting there just waiting for a hearing. But then, of course, filing now without an exception would be a violation of the moratorium. But if you're talking about the exceptions, yeah, it does show up. It's part of the record unless the tenant and the landlord agree to somehow either hide the caption, make it confidential, or do an expungement, which is a whole different thing.
Sure. From Sarah, wow, hey, somebody's citing a statute here. Do you always file an expedited complaint under 504B.321 when filing under an exception under the executive order? Specifically for property damage, I believe the seriously endanger landlord's property language under the statute is a higher burden and 24-hour service requirements are sometimes difficult, whereas the executive order states significantly damages landlord's property. Wow, that's a complicated question.
Yeah, I haven't found anything expedited about this process at all because they are reviewing those exception cases. Like I think I mentioned earlier, I had one, I waited a week just to find out if they were accepting it.
Yeah, I think even the 171 violations now have the 7-day rule in place, right? That's sort of a modifier from what existed before.
Right. So there's nothing expeditious about it, right? You still have to do the 7-day pre-filing notice and you have to wait for the court to take a look at it. So, and even if you are expediting, even in normal circumstances, the service requirements are too tight.
Okay. From Maluska, can you give incentives to a tenant on an oral lease to sign a written lease?
I guess I wonder if the tenant is paying and what those incentives are. If somebody wants to have more to go on by having a written lease instead of an oral lease, only to turn around and evict them for a violation, I'm not sure if that's the best strategy. So I need to know more about what that strategy is. Why convert them from something that isn't a written lease into a written lease? Unless you know you're going to get paid.
Well, Lauren was listening earlier. She's got to follow up to something you said. She's a landlord. Can you elaborate on the re-entry clause? If there's not a re-entry clause in our lease, does that mean we can't evict when the moratorium lifts?
It probably does, yes. Minnesota does require what's called a re-entry clause, and Mike could probably elaborate on this. It's in their training as well. This is separate from that clause that says we have the right to enter to fix things. It's actually in some leases, in the Minnesota standard leases, it says re-entry clause, and it is reserving a right to evict. It doesn't let you take over the property right away. It's just a reservation to evict under a claim of breach of lease. And it's required language. And so therefore, without a written lease, you couldn't possibly have that. So that doesn't work. But even with a written lease, at least the referees anyway in Hennepin and Ramsey will usually look for that language. They'll ask.
From Adriana, if an owner was able to refinance their property with a much lower monthly payment due to COVID-19 is he at all obligated to reduce the rent of their tenant?
No. Those financial obligations are separate, mutually exclusive. What the landlord gains or saves, it has nothing to do with the tenant, unless there's some really odd circumstance I'm not thinking about.
I get the logic of the question, but your answer is absolutely right. They're just not reliant on each other. Yeah. Okay, I think this is from a tenant or perhaps a social worker. This is a public health emergency. We're trying to save lives here by keeping people inside four walls. How can landlords who are able stop whining? How can rich landlords realize that small business landlords need their businesses saved before the medium to bigger businesses and the bigger firms recover in the economy like everyone else? So this is sort of the flip side of the questions we've been getting from landlords today, which is, this isn't fair to me. And this person saying, you know, hey, we're trying to keep the world intact, doing the best we can, I guess.
Yeah, I'm not sure it's really a question.
Right. Well, it is, Kim, because there's 4 question marks at the end of this paragraph. So by definition, it's a question.
It's a wonderful question.
Right.
Yeah, I don't have an answer for that. I don't assume all landlords are rich. I can tell you that they are not.
Right.
The property is property. Everyone has the same rights related to it. The statutes are the same for everyone. If someone has more resources to displace somebody, I guess that's their prerogative, but I don't have a good answer for that.
Sure. I'm going to combine these next 2 questions because they're similar, from Maluska and Christine. Can you give the tenant an incentive to leave voluntarily, or can we pay tenants to leave?
I think you can.
Have you negotiated any of those for folks?
I've done it in the past. I've done it several times. I mean, I've had tenants where we've had to pay them to leave. I don't know if I've had any during this pandemic. I've got some very good clients who probably know how to do that on their own. I mean, we've talked about it and we've done it in the past. Yeah, you can. I would not frame it as a threat. You know, I'm going to pay you, or and you're going to leave, or I'm going to evict you. You know, you have to take my offer. It can't be a threat, but certainly you can do a mutual agreement to terminate a lease. And I would do it in writing, and I'd address what happens with unpaid rent, if there is any, and what happens with the security deposit, just so there's no loose ends to deal with later. But you can certainly come to an agreement.
Sure.
Because there's a lease doesn't mean you're both stuck to each other.
From Paul, does a new owner, this is a different question, does a new owner inherit the liability of delinquent rent? I guess that's not really a liability, is it? Or isn't it more of an asset? If there's delinquent rent, that's something you'd be entitled to?
It could be, yeah. I usually see this cleared out at closing. So the transfer is clean, that even if there's past due rent, the previous landlord, the seller, takes responsibility for that, and it's done.
I assume the new owner could buy the debt, right? I mean, that's a possibility.
They could agree upon whatever they
Sure.
want, I think, as far as the sale of a building.
But you don't see that happening where the new owner is entitled to the back-room debt very often when they buy.
No, I think they try to make a clean break of it, even if that leaves the seller with unpaid rent. Because then the landlord coming in, and I've had this happen, the landlord coming in might be walking into something where they thought the rent was up to date, and it turns out they hadn't paid for 4 or 5 months, but they got a clean start. So from the time that they take over in that assignment of lease, they have to deal with an eviction or collection or whatever. So I would wonder, what is delinquent are these people who pay before I buy the building. That has more to do with cash flow than whether this is an asset or a liability. Does that make sense?
Sure. From Katie, if a landlord is saying someone owes past rent but can't give an exact amount or account ledger, what might somebody do? Just to expand on that, I assume you talk to your clients about the importance of having a easy to follow ledger of some type, right? Yeah. What's sort of the best starting advice you give for landlords on how to keep track of the rent? What do you tell them to do? What system do they recommend?
A rent roll, even if it's manual, you can use Excel, but always track everything, know where you're applying it, keep all of your bank deposits tracked, and do a ledger. I have clients that do actually monthly invoices, so that they're always sent, and they mail them or they drop them off. And it's pretty hard to ignore a monthly invoice that tells you exactly how much you owe. And it's also another way of notifying the tenant regularly of where to find you. Here's my address, my phone number, here's where to contact us. I think it's really helpful. I think collections improved greatly upon using an invoicing system, but I usually always have a ledger too. And that's what I use to try to calculate what's due and figure out late fees and if there's something that shouldn't be in there. And then I always have that at court. So when I sit down with a tenant and they say, I think this is wrong, I can say, well, let's go through it. And we'll go through line by line. And sometimes they just don't realize how much they owe.
In the Q&A portion, a statement from Paul Bernberg. This is, I think, a first for one of these sessions.
Hi.
Yeah, he said, note, no reentry clause required for a non-payment case. So once the moratoria are lifted, non-payment cases can go forward even without a reentry clause.
Right. We were talking specifically about breach of lease, I think, in that question and all along. Yeah, because you could even have an oral lease, no written lease with a non-payment case. It's just non-payment.
Sure. I appreciate him pointing that out, though, because like you say, we were sort of in one direction there.
And one note on that, the housing court rules, which are actually a little bit different, do rely on the idea that if you have a non-payment of rent and a breach of lease in the same eviction, the breach is heard first. So you could be really in deep before even addressing the rent.
Fair enough. Wow, here's a sophisticated question from an anonymous person. Are landlords able to obtain a valid waiver with informed consent from prospective tenants of their rights under the moratorium or to agree to an entrance of writ of recovery without an eviction trial? I think they're wondering if they can put in their lease that can a tenant sign away their rights to an eviction hearing.
That's the way I'm taking it, and I think no, no.
I think if landlords could do that, they would have that in their leases already. Yeah.
Yeah, you can't force them in writing to waive things most of the time. In fact, a lot of the statute says that.
Right. It'll specifically say it doesn't matter what your lease says or notwithstanding the terms of the lease. Those are the kinds of phrases you'll see in landlord tenant language. Yeah. Let's see here. Is there an organization or group for landlords to come together to share knowledge, receive guidance, or a suggestion how to start one? This is from Kimberly.
The Minnesota Multi-Housing Association is a landlord trade group. I know they do a lot of lobbying and they have resources for landlords. So that's
I'm not sure that they do anything equivalent to what we're doing with these sessions right now.
No,
right. I know they've done some presentations since COVID began, but I don't think they do any kind of regularly scheduled stuff like this. Let's see here. One last question with the time we have here. Oh, yeah, from Dan. Don't get me wrong. I would not do this. This is Dan talking.
Okay.
Don't get me wrong. I would not do this, but what happens if the boiler breaks? And since the tenant is not paying rent, I do not have money to fix it. Would the city give some kind of notice that it's not livable and the tenant would have to go?
Yeah, I think that's part of the answer and part of the problem, because if the city comes along and says that the premises aren't habitable, now the landlord could have some obligation to provide housing. So this usually gets into a pretty deep rent escrow emergency tenant action kind of a situation. But I wouldn't say, I almost feel like that was framed as, is my solution to call the city in and have them just say, you can't live here, and then they'll leave. But if you have a lease with them, and maybe even if you don't, you've got an obligation, do you have to put them up in a hotel?
Mm-hmm. Might be more expensive for the landlord in the end.
Yeah. So,
and I apologize. I said that was our last question, but I see one new one that we haven't really touched on from Margaret. Have landlords tried offering a delinquent tenant, so they owe some money, an agreement to voluntarily leave the rental and the lease, and in exchange, the landlord won't make any kind of adverse rental reference, or they won't file an eviction, or even give up the debt? Say, if you leave now, I'll wipe out the debt that you owe so I can get somebody in here that's paying on the first of next month.
Yeah.
Have you seen that? And are your clients working on that?
I have. I don't know if any current clients have. I've had conversations with people about that. I've even had somebody say, can I do this? Can I just say, I won't go after you for this money. I won't file conciliation court. I just want you to go. And maybe they'd be relieved at not having that debt. Yeah, they could come to that kind of an agreement. As an exit plan, they can come to lots of agreements as long as it's not waiving the rights of the tenant, who is a consumer in all respects. So yeah, and if they're going to have a clean record, I have a little bit of a problem with not giving an adverse reference when maybe it is adverse. Usually we might come into some language that says it'll be neutral. We just give dates and rent paid and leave it at that.
Sure.
And not say, oh yeah, they were great, when they weren't. Because
right. So it's not going to be a positive one, but they're not.
Yeah.
I think honestly, the best way to do it is to say exactly what the reference will include. So everybody knows what they're getting.
And
Yeah.
I've done settlement agreements where we do that, where we've got exactly what the landlord can say, and they don't usually care. But I have a problem with them lying about somebody being good when they're not, just to get rid of them.
Well, Kim, hey, thanks. This has been about an hour and 25 minutes of you just answering rapid fire questions one after another. Not an easy thing to do, and I really appreciate it. And we want to be respectful of your time, so we're going to wrap things up. But this has been interesting and very informative for me, and I'm sure for a lot of the folks that were watching today. So
sorry, my phone rang. I think it wasn't even my phone, it was my computer, and it wasn't the phone. So I couldn't turn it off. So, but I enjoyed it. Thank you. Thank you
Good.
for asking me back. And I hope people got some good information from all of us.
All right.
Yes, definitely. Thank you so much, Kim.
Thank
Again,
you.
Kim's info is up on the screen, and we will put the recording of today and the slides and some of the links and stuff that we provided up on our website after the fact. We're also going to apply for CLE credit. We'll give you information about that as a follow-up. Again, there's our hotline if you're a tenant and you have questions. 2 weeks from today, we've got another one coming up. I put the link in the chat. We'll be joined by 2 attorneys from Katie Pock from Legal Services in Northwest Minnesota, and John Buda from Smurls, who I saw is on today's session. So he knows what to expect next week a little bit. That's 2 weeks from today. And again, thank you, and appreciate everybody for joining us today. And again, thank you, Kim.
Thank you. Bye, guys.